Szczęść Boże, kłaniam się.
God bless you. Let me welcome you from the Polish Parliament in Warsaw at Wiejska Street. My name is Grzegorz Braun. I'm a member of Parliament. I'm the head of the Parliamentary Commission for Abuse and Infringement of Law in relation to COVID-19. I hereby open the 13th meeting of our Parliamentary Investigation Committee, which has become popular under the name Nuremberg 2.0. The 30th meeting, so a year has passed since we undertook this systemic work. But let me remind you that from the very beginning of this great operation of enslaving people in Poland and all around the world, we've been undertaking different actions and counteractions. We submitted notifications to the Public Prosecutor Office. We appealed to the government and leaders, and at the end of the year 2021, we launched the initiative of Nuremberg 2.0. Let me remind you that the objective and mission of this investigation committee is to investigate the legal dimension of all actions and events that took place, as well as all negligence of the government of Poland towards private and public institutions. So the legal and political dimensions. Of course, we also touched upon medical and scientific and even psychological and philosophical dimension of this threat that we had to confront. However, the ultimate objective of this team is to assign legal significance to all these events and actions taken. After a year, the time has come to review the situation and to wrap up activities that were undertaken and discussing the outlook for the future and next steps. Let me welcome our honorable guests from abroad, citizens of other states. We will be more than happy. Maybe happy is not the right word in this tragic context, but still we will be honored to invite you to the discussion and listen to your expertise. Today's meeting will be held by the chairman, Roman Fritz, member of the Confederation of the Polish Crown Committee, a political party that, thanks to which I became a member of the Polish Parliament. Thanks to that, we can pursue our goals within the parliamentary framework. So whatever is said here and heard here, it will have a specific and significant status, and it will be recorded as in the archives of the 9th term of the Polish Parliament. So let me thank you, and I leave the floor to the chairman, Fritz. Thank you very much. Once again, God bless you. Let me present the main topic of our today's conference and meeting. It's an international conference devoted to our current legal actions, aiming at holding accountable for the actions taken during the pandemic. Let me welcome our honorable guests from abroad. But before I move towards that, let me present all people present here in the room at the Polish Parliament. Piotr Heshen, who is member of the committee, Adam Kania, the coordinator of Nuremberg 2.0 project, Grzegorz Braun, no need to introduce him, Dr. Marcin Sowiński, who will take the floor at the end of this conference, Agnieszka Kutylowska, Professor Ryszard Zajączkowski, and other guests who joined us today during the meeting. So just shortly, let me bring you closer to the agenda of this meeting. We'll start with the connection. Before I will leave the floor to Adam Kania in order to wrap up the achievements of our parliamentary committee in November. Then we will connect with Georg Perklik from Austria, a lawyer. Then we will move towards and we will listen to Agnieszka Kutylowska. And then after 1 p.m., I think 1:15, we will connect with Dolores Cahill, immunologist. Then we will connect with France, with Paris, and we will have an opportunity to listen about the legal situation in the context of the COVID-19 pandemic. Dr. Diane Protat. And then we will devote some time to the pandemic-related topics in the presentation delivered by Marcin Sowiński. So now I leave the floor to Adam Kania. Please wrap up the achievements of Nuremberg 2.0 in November. Maybe not only in November, but as it was said, I think it's a perfect moment to summarize the entire year of our operations. Maybe I will not go into details of what happened specifically in November, because this month was concentrated on analysis and review of our current activities, but a few important information on our achievements as Nuremberg 2.0, our successes, and fruit of our shared commitment and work. Not only this, which is visible and which you can see online in the media, but also in the backyard, the work which is invisible and you're not aware of it. Let me remind you that we have about 360 lawsuits related to different topics and different issues, from the trivial things like somebody was not accepted in a shop because they didn't want to wear a mask, through some more serious lawsuits, so leading to somebody's death, of people who were not accepted and administered to the Polish healthcare centers during the so-called pandemic. So there are many such cases, a dozen of them. In some cases, it led to the patient's death. Yes, I stressed that. So the project is concentrated on a dozen of instances leading to patient's death. The most popular ones became well popularized during the third Nuremberg conference. We had an opportunity to listen to Ms. Bednosh talking about her daughter. But we also have some investigations which were notified to the Public Prosecutor's Office from Częstochowa and Gdańsk. So a series of different lawsuits and notifications dispersed all around Poland. Thanks to the courtesy of the Member of Parliament, Grzegorz Braun, we have made over 60 written interventions before different public institutions, and besides the written interventions, we also carried out together with Mr. Braun 12 or 13
raz w miesiącu byliśmy w jakimś miejscu i
So we intervened in many different places, different public offices, units of the local government and budgetary units. So I will not deep dive into all of them because you can follow the story via our social media and our website. So apart from all these written and personal interventions, the project has sent over 1,000 different letters and requests. Also to attract attention, to express appeal or reservations. These were requests for the access to the public information. So we have produced a lot of such documents which were sent to many public institutions. The project was also engaged in about 9 actions with regard to notification or appeal against press conferences organized all around the world, all around Poland, of course, with involvement of the structures of the Confederation of the Polish Crown, but also many other organizations. So these actions were also spread all around Poland, and we were highly engaged. The aftermath of our actions that we took is that a dozen of cases is investigated by the Public Prosecutor Office on the 22nd of December in the Warsaw Court. There will be a hearing with regard to our complaint with regard to the termination of investigation by the Public Prosecutor Office with regard to the parliamentary intervention that was carried out at Mr. Szumowski at the National Institute of Cardiology, the public prosecutor, having analyzed the evidence, as he explains in the explanation based on the testimony provided by Mr. Szumowski. He stated that he finds no grounds for such accusations, and we have a relevant recording despite that confirming that it was a fact. So we are waiting for this decision, which will be issued on the 22nd of December. So we strongly encourage you to follow this case and to stay tuned. If any one of you is in Warsaw as a Polish citizen, you can witness this hearing of this court. Hopefully, the truth will win. It's a very significant case because the notification that we filed concerns the former Minister of Health, so the person responsible for the entire construction of the sanitary segregation through getting people accustomed to the tyranny of lockdown. So we've engaged in different types of actions to block detrimental acts of law. Some of them were blocked successfully. Some of them were passed and adopted by the Polish Parliament. But in each of the cases, we did our best in order to inform the public about some disturbing events going on. So what will be the future? We will see. If you are concerned with the future of this project, we are not able to continue without your contribution in order to finance different actions with regard to this project. So we are strongly encouraged to support us financially and to support our budget for the year 2023. Without all these contributions, we will not be able to organize actions like that. For example, this meeting is interpreted, so we had to engage technical staff and interpreters, so people taking care of the technical aspects of this conference, and we need to bear the cost of such services. Nobody will provide us with them free of charge. For that reason, we need your contribution and your financial support in order to continue. We know, because we have some leakages from G20, that it's not their last word. So I think a lot of work ahead of us with regard to these topics. And our ultimate objective is to provide some legal framework for all of that, and to bring indictment against all perpetrators who will not, who will be held accountable. Let me just note that this meeting is organized in the darkest times, because the current Minister of Health, the incumbent Minister of Health, as we used to call him, the Minister of one disease and rapid death, Adam Niedzielski, he informed us that, and he informed that as the propaganda of success, that he's just launching a vaccination campaign for children and even infants, starting from the 6th month of life until their preschool age. So that is the recent announcement, and at the same time he announced another wave on pandemic for January 2023. So the minister who showed his prophetic skills, he's announcing now that in a month the pandemic will achieve its peak in our country. So this is the exactly perfect context for this meeting, and for sure we're not talking about things of the past that are terminated and are outdated in any way. So please continue. Thank you very much, Adam Kania. And now let me join the appeal for financial contribution and financial support for our actions. We have an impressive we have some impressive achievements, and thanks to the fact that we can use modern technologies, we can connect remotely online with the first of our guests from abroad. So now let me invite a guest from Vienna, Dr. Georg Pyrchlik, a lawyer from Austria, will present the situation in his country over this mad period. Doctor, the floor is yours.
I zapraszam do wypowiedzi.
The floor is yours, if you will.
Jeszcze raz poproszę.
Once again, let me just make sure if Georg Pyrchlik is with us. Are you connected online with the conference? Please let us know.
Hi, I'm here. Did a conference start?
Hi. Hi, George. I don't know, because I don't exactly, I hear you, but I don't hear our friend Skalik.
I heard Mr. Stalik saying, well, you are here. But I only see on the split screen you and Mr. Stalik and me. and nobody else.
Yeah, I'm looking. There is another link that I did receive. No. Okay.
Possibility of
Maybe someone sent me another link. Because
why are this link?
Nie, widzimy doskonale i słyszymy.
No, we hear you perfectly and we can see you. We hear you and see you perfectly, and we ask you to kindly take the floor, Doctor.
Well, it's 26. Shall I start now?
receive no.
Yeah.
God, I think you are on the air. You can.
Tak, bardzo prosimy o to.
Yes, please do take the floor. Please do take the floor. Yes, it is your turn now.
Słyszymy i widzimy pana doktora.
We can hear you and see you perfectly well.
Good morning. My name is George Bruchlik. I'm speaking from Austria. I'm an attorney at law in Vienna. I want to give you a short overview over our legal system, our constitutional system especially, and then to speak about some details of the so-called pandemic period. Our legal system is based on our constitution, which has as a part the fundamental and human rights of the European Convention. How does our system work? We have a legislation exerted by the Parliament consisting of two chambers. The lower chamber, the so-called Nationalrat or National Council, that's dependent to your Sejm, the lower house of your Parliament. And we have a Bundesrat, the Federal Council, which is more or less the upper house of our Parliament. The Parliament enacts the laws. Those laws are used by our administrative authorities on the one hand and our courts on the other to rule the country. Especially in pandemic, we have a certain aspect concerning the activities of the administrative authorities. Our constitution says Parliament passes a law. On the basis of this law, the administrative authorities may issue orders. And that's a core element of our legal system, the law must sketch out, must define the possible content of an order exactly. The administrative bodies are only entitled to fulfill the law by giving an executive order, and they are not entitled to issue orders which are in contempt of the law. The law has to define the content of the order, and the authority has to put this law into an order which is not anything other than just the execution of this law. So we call it implementing order because it implements the law. That's the crucial point in it as far as a pandemic is concerned. The legal system is controlled by the Constitutional Court. The Constitutional Court consists of 14 judges, a president, a vice president, and 12 normal members. The president, the vice president, and 3 members are appointed on a proposal of the government. 6 members appointed on a proposal of the government. 3 additional members are appointed on a proposal of the lower house of the parliament, and the last 3 members are appointed on a proposal of the upper house of the Austrian parliament. So all judges are appointed based on proposal of political institutions. Being a constitutional judge is not just a job of real independent jurisdiction, it's a job of political concern. This constitutional court has a large field of opportunities to control the system. For example, there can be filed complaints against laws saying that the law is not based on constitution, and complaints against orders saying that the orders are not based on laws. But there is an additional problem in it. How can you file a complaint to the Constitutional Court? Who can do it? Certain administrative bodies can do it, as the government, and parts of the parliament can do it. But what about the people on the street? Can they file a complaint against a law, against an order? Yes and no, but mostly no. The crucial point, the catchword in it is direct concern. A complaint against a law or against an order of an administrative body can only be filed by people who are directly concerned by this law or this order. That means this law or order has to touch the interests of the people without any judgment of a court and without any decision of an administrative body. Those are very, very, very few cases in which this will act. For example, during pandemic, the Austrian authorities in the Tyrol closed a small town called Ischgl. And some people living in Ischgl tried to cross the borders of this enclosure, yes? And they saw police cars and stopped and turned and got back and then raised a complaint against the government saying, well, those orders were wrong. They were not based on law. And the Constitutional Court said, no, you are not entitled to file a complaint. Why? You were not directly concerned by those orders. You should have tried to cross the police line and then to be caught by the police. And in this way, you could find a kind of decision of the police you could use as a basis for going to the Constitutional Court. Yes? So the normal way for a normal man, a normal woman, to go to the Constitutional Court is to get a decision of an administrative body and fight it, and in last instance, they can go to the court, or to get a judgment from a court, fight against it, and in last instance, you can go to the Constitutional Court. That's a question of time, not of weeks, not of months, normally of years. So in practice, you can forget it. Yes? Now to the pandemic situation itself. The Austrian government made a lot of draft laws concerning the question of COVID-19. Basic was the COVID-19 measurement law. This COVID-19 measurement law offered the Minister of Public Health the possibility to issue orders to take adequate measurements against the spread of COVID-19, against the danger of COVID-19. And he did so, or at least he said he would do so. He ordered lockdowns, he ordered the closing of whole districts, the closing of communities, and so on. And those orders were fought by our lawyers from the Austrian Lawyers Association for Enlightenment and Fundamental Rights, a member of which I am. But the success was not very great. In the first period, we were successful. Why? The Constitutional Court said, well, an order must be based on a law, or it wouldn't be an executable, implementary law. And this, using the law as a basis, must be documented in a file by the minister. The minister has to say, well, those are the reasons why we have been entitled to issue the order. In practice, the minister issued orders, said they are based on the COVID-19 measurement law because they are adequate measurements against the spread of COVID-19. But the special files documented the adequacy of those measurements, saying, well, there are so and so and so and so medical problems, and therefore we have to fight them by those orders. Those files were empty. Not only small, not only thin, but empty. And the government really handed over empty envelopes to the Constitutional Court. And so the Constitutional Court said, no, that's not really the way. We put aside those orders. They are not correct. Yes? This decision was completely based on formal aspects. The Constitutional Court did not decide on the questions, well, are there epidemical problems? Are there problems in the field of health? That was completely interesting to them. They said the formal order was not fulfilled. The envelopes were empty, and so the orders are incorrect. The government learned, and in the next cases, the government handed over envelopes with studies in them, envelopes with decisions of a commission concerned with epidemiological problems. And now, our further complaints did not be successful because the Constitutional Court said, well, the minister issued an order saying lockdown. This order was based on those studies in the file. And this is enough for the correctness of the order. Of course, we had offered the court a lot of contradictory studies, of other studies, 50 studies, for example. Yes? But the Constitutional Court said we are not forced to read those 50 studies because The minister has given us an envelope containing one study, and so the minister has based his order on some logical ideas. This is enough. We don't have to check whether the study offered by the expertise offered by the ministry is correct or not. We just check, do they have based their decisions, their orders, on such an expertise, and in case they did, the order is correct. And so we lost a lot of cases. And the Austrian Constitutional Court never ever really checked the medical questions. They said, well, those measurements are based on an expertise in the file of the minister. We do not check the expertise. Forget your studies. That's not the one way, yours. But there were certain problems additionally, for example, with the issue of the orders. In Austria, laws and orders can only be passed or issued by a publication in our Bundesgesetzblatt. That's a kind of journal. In this field, the ministers spoke at press conferences and spoke about orders which would have been issued, but we could not find them in the public journals. This was one way. The other way was using a special brief of our law-giving procedure. Normally, a ministry or the government files a draft law to the parliament and say, please pass such a law. And the government takes a decision, says, yes, fine, we enact a law based on this draft. But there is a possibility to change the draft. You can file a draft, you, the government, the ministry, can file a draft to the parliament and say, well, that's my draft law. Take a decision on it. The parliament will establish a commission concerned with this draft law. And in the sessions of this commission, the members of parliament may file an amendment to this draft law. They can say, well, we have found draft law, but now in the commission's discussion, we alter it. Normally, they alter one or two words. But in the cases of pandemic, in two prominent cases, they made a draft law consisting of 4 lines. In the commission's discussion, they altered the draft law to 200 lines. What's the philosophy of it? Well, in case the government or the minister files a draft law, this draft law will be sent to different organizations for public discussion. And in case there is a file for amendment in the commission, this file will be sent to nobody to be publicly discussed. So by using the possibility to alter a draft law during the discussion of the Parliament's commission, they could more or less exclude any public discussion. The public knew only the 4 lines of the original draft law. And the 200 lines of the draft law authored in the Commission were just sent to the main body of the Parliament and accepted with the votes of the majority. The majority is the government's party. There are two parties in the government. So they tried to hide laws. And sometimes my colleagues who screened the Parliament's papers, the Parliament's documents, day for day, just gave me a call and said, don't you know, yesterday they passed a law. Nobody got any notice of it. They tried to hide it. That's the one way with which we are confronted. And there is a second way concerning the content of laws and orders. Once they tried to enact a law saying that being vaccinated would be mandatory. This law was highly criticized, and after some months was postponed and then was cancelled completely. No mandatory vaccination. The Austrian Chancellor saying in the public, no mandatory vaccination. We don't touch the freedom of the people. Complete nonsense. Because they passed a law called an amendment to the law of epidemic threats. And this amendment authorized the Minister of Health to do the following: to state that a certain virus would cause a threat, serious threat to public health. And second, to form some measurements against this threat, the so-called restriction of contact. That means, based on this law against epidemic threats, the minister can say all people infected, all people showing symptoms are not allowed to enter cinemas, to enter restaurants, to enter means of public transportation. So now, after having set aside the law of mandatory vaccination and having put the amendment to the law of epidemiological threat on the other hand, we have the situation that the government says nobody is forced to get vaccinated by mandatory vaccination. Anybody is allowed to stay unvaccinated. But those guys and dolls who are unvaccinated are not allowed to enter a cinema or a restaurant or a means of public transportation. That means we have switched from mandatoriness, that means from a threat of criminal investigation, if we call it in that way, to just pressure. Pressure via possible restrictions of your life. You are not forced to be vaccinated by the threat with a fee of 20,000 euro. You are pressed by the threat of not being able to take part in normal social life. Great problem is that many people, the great mass of people, does not reflect it, does not understand it. After the putting aside of the law of vaccination, of mandatory vaccination, they say, we are free, and so we are not forced to take part in demonstrations or public rallies and show the government our wealth, because we are free. There is no danger of this. They do not reflect the danger of the epidemic. And there is a third problem. They put pressure on the doctors via disciplinary law, via disciplinary tribunals. There have been a lot of disciplinary tribunals against doctors who had said, well, we think that vaccination has dangerous side effects. And the disciplinary tribunal of the so-called Chamber of Doctors, it's an organization to control the doctors, the disciplinary tribunal said, well, they are endangering public health. They say vaccination has dangerous side effects, so many people will resist against vaccination, will not get vaccinated, and they will die a cruel death. And so those doctors who speak against vaccination are potential murderers. And the threat was they can, or is, some of those trials are still on, and the threat is they can lose their appropriation as doctors. That means their allowance to act as a medical doctor. And that's a very, very grave pressure. They can lose their jobs. I spoke to many doctors, and I represent some of them at the tribunals in court, and said, well, what are you thinking? And they told me, well, we are really endangered in our jobs. One of those doctors left Austria for Oxford. Another one left Austria for Tanzania. They said, we do not want to live here. They put danger on us. They put pressure on us. And another way we are concerned with those matters are the dangerous side effects of vaccination. In my law firm, one important field now is coming in for compensation for damage caused by vaccination. And it's very hard to find doctors who are ready to say, well, that's an effect of the vaccination. We asked some doctors, why don't you do it? One lady client asked the doctor, and he said, well, I want to keep my appropriation. I want to keep my job at the public hospital. I know, be sure, I know that vaccination is the reason for your problems, for myocarditis. But I don't dare to say it publicly because I would use the economic basis of my life. And those are the threats with which I'm concerned now. And I want to know, do you want some special answers? Do you have some special questions?
Bardzo dziękuję panu doktor.
Thank you very much, dear doctor. Do you have any questions or remarks in the room, or would you like to comment on what you said? So, Professor Ryszard Zajączkowski.
I can't see Professor Zajączkowski. I can only see Diane. And
Teraz już dobrze. Now it's okay.
Now it should be fine. I've got one question. Why, in your understanding, the Constitutional Tribunal didn't take a closer look at the medical expertise?
There is mainstream opinion. First, corona, or respectively, the disease possibly caused by corona, COVID-19, is an extremely dangerous threat to the health. And so all other ideas has to be put aside. I want to express it that way. In case one tries corona, nobody else asks any question. It's corona, so that's priority. And the doctors see it in the same way, many of them. But from my experience, there are three groups of people. First one, those who really believe in the threat of the health, to the health. For example, as I told you, the president of our constitutional court was in discussion with me. He came to the campus of the university with a mask, sat down, lowered the mask, discussed the matter with me, put up the mask again, and immediately left the university campus. He was a horrible threat to be infected. And a high-rank professor in the field of constitutional law was in a discussion with a female colleague of mine, and after that she told me, well, I had the impression that the professor was really in fear. He feared to be killed by speaking to me and getting infected. That's the first group. Those guys and girls who really think we will get infected and we will stop in our tracks and fall down and be dead immediately. As one guy told me. The second are those who want to do all things wanted by the government, not to resist the government in order not to endanger his own job. I spoke to many guys. They say to me, well, I know what you say. I understand it. From a scientific point of view, to one guy, a doctor, said, well, I know that this vaccination by a syringe and vaccination into blood cannot stop an infection caused in the upper respiratory section. I know it as you told me, but please consider, I have a firm with 40 employees, 40 hungry mouths to be fed. I cannot risk to lose my appropriation. I cannot risk to lose my job. And so I will say vaccination is effective. Not to the fact that I would believe in that nonsense, but to the fact that I have to say it in order to stay in my job. And the third part, people who do not really think about anything, but who run with the mass. And in case the mass runs to the left, it will run to the left. In case the mass runs to the right, it will run to the right. Those, they form the majority. And so, you may not expect that any doctor or any high judge will leave this consented area and say, well, I do not think that. In case he wants to keep his job, he has to say, well, I'm completely convinced COVID is an incredible threat to us, and the vaccinations are the incredibly good fight infectious means to hinder, to impede the spread of COVID. Have I answered your question?
Proszę bardzo, pan doktor.
Dr. Marcin Sowiński will continue. Welcome, dear doctor. Our warm regards from Poland. Let me ask another question. It seems that in law, the expert doctor from Germany can be used as an expert at court. Is it possible that, for example, Professor Bardi could present his studies and results of his studies, biopsies and other, because he says that the antigen as can be presented, and when it comes to the nucleate capsid, we have the evidence that it appears after COVID-19 vaccination. My regards to you, dear doctor.
Dear doctor, you are completely right. Of course, Austrian authorities, maybe administration authorities, maybe courts, might use experts from all around the world. But that's not a question of the possibility, the legal possibility to use those experts, but the question of willingness. Our authorities are unwilling. For example, we filed complaints to the Constitutional Court with a lot of expertise. Yes, I think something like 50 studies concerning different matters, statistic matter. I have studied statistics too, and so please allow me to say those statistics are correct. Statistic matters on vaccination, on effects of vaccination, and so on. We presented those expertises to the court. The courts did not use them. One example. A so-called administrative court of first instance. Small excursion. In Austria, we have the first instance of administrative decisions, an administrative body, an administrative authority, which takes the decision, and against this decision, you can file an appeal to a real court, the so-called administrative court. Yes? And against the decision of the administrative court, you can go to the constitutional court. And in one case, I had a lot of studies, really a lot of studies, many of them from Israel, saying that my point of view presented in this litigation would be correct. And the judge said, well, doctor, it might be that you have 200 studies saying that this is correct, but due to our law, I have to judge whether the decision of the authority, the administrative authority, was acceptably based on an expertise. And in case they find just one expertise saying that the decision of the administrative authority would be correct, I, as a judge, am not allowed to put this decision aside. And Belashnik, he told me, there is one expertise coming from Berlin, coming from their expert, I don't mention his name, I've put it aside in my head. And this expertise says the basis of this decision is correct. And you may offer me 200 expertises against. That's uninteresting. The administration body has based this decision on an expertise. That's enough. But in this certain case, the judge said, well, I offer you another possibility. The decision was filed, as I know from my papers, not to your client, but to the email address of his wife. That's incorrect. So I'm sorry, the decision of the administrative body is void due to using an incorrect email address. You see, the judges of the lower courts themselves do not believe in this nonsense, but their hands are bound in most cases, only if they find some formal aspects. They are ready to put aside the decision, to cancel the decision. And the Constitutional Court that does not use those expertise because the judges say, we are constitutional judges. We are pure lawyers, normally not involved in, as I call it, real world matters. They do not state the real situation, they just decide on legal matters. For example, they just, as I told you some minutes ago, they say this order was not correctly based on the legal fundament because there was a formal mistake. But we, the judges of the Constitutional Court, they say, we are not entitled and we are not ready to check the material aspects, the medical aspects. It's not our job. It's our job to check whether those decisions have been taken legally and not whether this or that medical theory is correct. In case they can base the authorities can base their decision on some evidence, on some expertise, we will call the decision, the order, the law, etc., correct. In spite of all the expertise which is on the other hand. That's our problem. Many of my friends say, well, we have 10 additional expertises. We go to the court and we will win. Lawyers say to them, no. They will drive you out. They will say, we have one expertise saying that this is correct. That's enough. Have I answered your question?
Serdecznie dziękujemy panu doktorowi. Przypomnę, że
Many thanks to you. Our first guest was Georg Perlich, PhD, lawyer from Austria. Thank you very much. Now, second to speak, Agnieszka Kutylowska, who has been working directly with Justyna Socha and StopNop organization. She'll talk about the collaboration with lawyer Martin Sztetela the last 2 years, about freedom of speech among doctors, and about side effects of vaccination and assistance to those suffering from secondary effects. The floor is yours. Welcome. Hello. I'm speaking. Hello, can you hear me? All right. Testing? Yep. Okay. Let me read out a statement by Justyna Socha, who couldn't reach us, unfortunately. Please treat this as if it was Justyna speaking, because these are her words. Then I would like to add something on top of that from my own self, on my own behalf, if time allows. Starting from early 2022, in collaboration with lawyer Arkadiusz Tetela, and always being able to count on Grzegorz Braun's help, I have taken up activities legal, among others, to protect human beings. What action has been taken, what the results are, and what else should be done to make accountable those responsible for the pandemic dictatorship. First of all, the win in the case against the Minister of Public Health and access to public information of the Warsaw Court, which ruled that the Minister of Health infringed the law by not granting answers to important questions, and the court obliged the minister to respond. One of the questions was the following: what are the assessed costs of the medical issues of the total population of Poland due to stress, lack of fresh air, lack of natural sunlight, negative effects of face masks, isolation, social isolation, quarantine, and the paralysis of the health system? How many people have lost their health and lives and might in the future? The minister said, this is not the entire answer, just an excerpt. Sorry, let me find the right passage. The minister does not have such estimates available in those respects. In the second part of the question, how many people have died, the answer does not have any information. The following part regarding the effects, side effects of lack of access to sunlight, natural sunlight, fresh air, etc. The minister is not holding any statistical data in those regards. The ruling of the administrative court is proof of lack of responsibility for decisions made by the government in lockdown measures and lack of freedom of speech. Protests started early in the lockdowns. The first protest, international protest against obligatory vaccination, took place, and then marches for freedom from October 2020, when activists from 50 towns were invited. Police were ever more active against our request for an open debate with specialists, experts, doctors. We were met with police brutality, and this was the biggest pressure against freedom of speech incited by Minister Niedzielski, who announced zero tolerance for those infringing official measures, lockdown measures. In October 2020, in the Mazowsze Voivodeship, 300 people were arrested, although they were protesting peacefully. They were met with several accounts of accusations, and the court in Warsaw City, in 109 cases, ruled that the arrests were ungrounded. The proceedings took over a year in some cases, and the arrests were announced illegal. this year. The same year, there were complaints against unfounded arrests, including the Katowice court, which ruled a fine to be paid for the benefit of the arrested person, standing at 10,000 zlotys. With Mr. Lawyer Arkadiusz Cetel, we won a series of cases, including against the mayor of Warsaw, for cancelling the 21st of March 2020 March for Freedom. Further activities. What else can be done? If an arrested person knows the personal data of the policeman, they can complain against the policeman's action. All those that were arrested during a peaceful manifestation can complain against the chief officer of the police. What else did we do during the pandemic times? We have over 100 cases against physicians who publicly commented on their personal views. They officially can't comment on medical issues. And regardless, medical chambers exert pressure on physicians. As a result, physicians launched an independent association of doctors and scientists, which is first of this kind, which we have awaited in Poland for many years as a movement fighting against tyranny, medical tyranny. Health is a state of full well-being mentally and physically, and not only a lack of disease, which is a quotation from the WHO document of 1948. The ethical code, the biggest ethical determinant for the physician, is the well-being of the patient, and any kind of pressure does not constitute grounds to free the physician from this duty. And what has been implemented causes more bad than good, and we call on the authorities to make a step back and go back to normal functioning of the state, of the legal system, to respecting human rights and civil rights. This was the first appeal, supported by over 1,000 physicians and medical professionals in 2020. Then there were petitions, appeals against COVID measures, against sanitary segregation, after many months of hearings in all Poland. Recently, 100 doctors who were fined for voicing their views on vaccination, obligatory vaccinations. There are 3 hearings in Poznań, Wrocław, and another city. The dates are not yet defined in these cases. Justyna presents the details of these cases. Katarzyna Borowska, head of the Independent Association of Doctors and Scientists. The Beskidzki Professional Court Tribunal made a hearing regarding her views on vaccination for pregnant women and infants. The same court decided to suspend the physician in her professional rights for that opinion for 1 year. The decision is currently legally binding. Arkadiusz Cetel presented a number of results of studies which show how important it is to build the awareness in patients about their rights. Another case, Anna Furmanik, case of 2022, the professional court in Warsaw ruled against Anna Furmaniuk and decided to suspend her in her professional rights for 1 year. While the case was to suspend her for 5 years, Arkadiusz Tetela filed for clearing her of the accusations. This was for her opinions in which she said that COVID is untrue, it's fake. She appealed on polls to not get vaccinated and saying that the system will not bear their side effects for the next 30 years. The ruling can still be appealed against. The other case is of Dr. Dorota Sienkiewicz, head of the Independent Association of Physicians and Scientists. She had a ruling in 2022 for her opinions voiced in an appeal to children and youth, and she was suspended for 1 year. The ruling took between 3 p.m. and 9 p.m., in which Arkadiusz Tetela screened current knowledge in terms of threats of vaccination, and the ruling was made unpublic, although regulation says that it should have been public, which infringes Article 43, 1 of the Bill of on the rights of doctors and dentists. The ruling is going to be appealed against by the accused, then by the defendant. We have filed a complaint to the Constitutional Court, which has not yet been heard. If the ruling is positive, then the participation in the self-governing body of the Doctors' Association will be voluntary. Now it's obligatory. And we managed to stop very dangerous draft laws regarding 1846. Currently, there is the illegal duty to be vaccinated for medical professionals. Protection for vaccinated with side effects in their families. We have seen ever more families willing to fight for their rights. Some cases are rolling. Other cases regarding side effects will require all kinds of proceedings, formal proceedings. The easiest way is to file against the producer, but the ministry makes this very difficult. It is unclear by whom have the producers of the vaccinations been waived of responsibility. We don't know whether the waiver is in force or not for the responsibility of the side effects of these products. So a complaint has been filed to the administrative court, and we are waiting for a hearing and a ruling obliging the authorities to respond. The manufacturer is accountable for the product based on risk, and they have to prove that there have been no negative side effects. In the case, they have to prove, while it works the other way round in the case of private complaints, which you know all too well that in the current situation is close to impossible. It is impossible to receive certificates for post-vaccination deaths. Statistically, there were 8% more dead Poles, and it is difficult to establish whether this was due to vaccination and side effects with heart disease. Like, for example, the protein that causes the inflammation of the heart muscle. Then there is the case discussed by Justyna of the 21-year-old David, one of numerous cases. On November 23rd, 2022, the District Court in Wrocław terminated the investigation upon the possibility, in terms of possible vaccination having caused the inflammation of the heart as a result of the presence of the protein causing heart failure in his blood. There are still chances for reaching justice in this case. Vaccination for infants and small children. Adam Niedzielski recently announced a Pfizer vaccination action for children up to the 5th year of age, which has been mentioned by the member of the parliament, ignoring completely argumentation of the medical environment and the fact that many countries have not gone for such a step. Uruguay has stopped vaccinating children below 13 years of age after a judge ruled that all such vaccination actions have to be suspended until the presentation of the agreement of the government with the manufacturer due to possible risk of heart failure and other complications in the circulatory system. Dr. Witczak talked about vaccination of children against COVID-19 and its small benefits and very large threats. Thank you very much for the opportunity to present the achievements of Arkadiusz Satela, who has been supporting Stop Now for many years. We are fighting for a free choice for parents in terms of vaccination. This is more important than ever before. Many thanks to Grzegorz Braun, a member of parliament, started already in December 2019, where first totalitarian draft laws were processed in the parliament due to the pandemic being announced by the WHO back then. It is very important to reach the wide public with our message of truth and holding accountable those responsible. Thank you very much for your attention. This is all on behalf of Justyna Socha. May I add something on top of that? Yes, please. A big thank you on my part to Justyna Socha, to the entire environment of Stop Knob, to the association. We have convened and met on and on here in the parliament, in the streets of Polish cities, but mainly in the capital city of Warsaw. And I think that if history is ever written by Poles for Poles, will appreciate our action. Please continue. Dear member, let me stress that a member of parliament, Grzegorz Braun, has been with us starting from 2017. I will never forget what you said back then. You said you are on the front line of this battle for civilization. Following topic, and ask you to comment. Of course, this is strictly related to issues we are dealing with here. That is the legal framework of the situation we currently find ourselves in. Like the lawyer said, Lawyer Pchlik, what was key in all this was the medical environment. And it's important to reflect on what a legal environment physicians operate in Poland, and not only in Poland, also beyond. And I'm talking about the Act on Medical Chambers, and particularly the institution of professional courts of the medical industry. So the question I like to pose is the following. These professional courts of physicians Sorry, I have to really weigh my words. Let me start with the Constitution. The Constitution of the Republic of Poland in Article 175 says that the legal system is the Supreme Court, region district courts and others, military courts, but there are no other courts. So the question I like to ask is, how is it possible that this act, which was written before the Constitution, it was created before the Constitution, and such an institution, I mean the courts of doctors, professional courts, which have legal judiciary remit and penal, because the penal code says that, ladies and gentlemen, the issue of the right to perform as doctors, rather the right to suspend and those professional rights is within the catalog of penal measures. The ban on performing a certain profession, this is taken from the penal code. So, quite obviously, this institution called a court, or is it legally? Actually, is it legal to call it court? They do have judiciary power. And it's like a state within a state. It's an authority. It's a judiciary authority outside of the Constitution, completely outside of it. And this means that professional environments, like mentioned by the lawyers, the medical profession is in a trap because there is legal out of measures taken against the constitutional system. There is legal action taken against those people, which is completely unbased in the Constitution. After such a legal case, a court case, the doctor can only appeal to the Supreme Court. I don't know if you were aware of the fact that there's the Doctors' Chambers Act of Law. The rulings of the doctor's chamber can only be brought into question by the Minister of Health by complaining to the Supreme Court. This is really a separate system. It's some kind of construct that really has to be looked into in close detail. Right. That is very true. Thank you very much for drawing our attention to this aspect. It is quite sure, intuitively speaking, and there is ever more proof to that. The further we go with our work, we've seen the conclusion on many opportunities that indeed it is a state within the state. That is, we are dealing with organized action, and action taken in the territory of the Republic of Poland and beyond by organized structures, organizations that are exterritorial in their nature, organizations uncovered by the Polish law, and the public authorities of the Republic of Poland have on many opportunities concluded in our, for example, parliamentary interventions, like in the case of the National Institute of Health, the Hygiene Institution, National Hygienic Institution, said that the distribution of experimental products called vaccines against COVID-19 in the Polish territory takes place with the acceptance of certifications issued outside of Poland that have not been verified in Poland and that are not planned on being verified in the Polish territory. In one case, the shocking formulation was used, namely, "Our hands are bound," as one head of the institution told us. So, continuing on this strand, Indeed, this is a very serious issue. This is a conclusion that we have drawn on many opportunities. This is extraterritorial action taken by persons, organizations, and structures. Let me add on top of this that the conclusions that should be drawn from this, I think, should be systemic action, not only towards bringing individual cases to court of individual persons, individuals that have been touched by these tragedies and damages. We should be looking for legal solutions that would make it possible to bring into accusation the structures. And I see that we have reference points in the history. Let's take the Nuremberg courts, and this was a case against criminal organizations. This was an extraordinary tool of not drowning in the details so that we can see the forest through the trees, so that individual issues do not blur the picture of the entire system. It was concluded, yet before the rulings against individual cases, the criminal is rather an addition to the entire system. But the Minister of Health and their organizations, the epidemiological stations, the sanitary and epidemiological inspection, all these are an open-ended list of organizations, structures, legal entities, legal persons that are initially nominated to the list of criminal organizations. You know all too well, this stems from what Dr. Plik said, from what you said, and from what Adam Kania said before. Ladies and gentlemen, we have some success, bigger and smaller. Some cases have been won, damages ruled. Bravo for that. But we all understand that neither in Austria nor in Poland, not here on the other side of the world, we cannot have an effective documentation, because again the leitmotif is the rejection to grant an answer by institutions which is breaching the law. We will not live to the day when crime is documented, and even less that being assessed by courts before we see changes in power and the governments. But in the meantime, we have a duty to document particular cases, describing cases, keeping documentation, corresponding with institutions, even if we don't get responses. But we need to have a vision of the future at the same time, and that vision of the future is a situation in which criminal institutions are treated like the agendas of the National Socialist system in Germany, or the communist system agendas in Poland and other post-communist countries. The secret services in Poland, committees, central and voivodeship committees of the Workers' Party were liquidated. And so this is the Polish perspective, and this is something I'm concerned with. The Ministry of Health is an institution that committed these crimes on Poles, and this is the institution that has to disappear and has to be dismantled. It cannot be shifted by some kind of staff change. It has to be completely destroyed and built anew in a different place, because in this place some kind of museum of martyrdom of the COVID era should be organized, and the battle of nations against the alleged pandemic. This is this is my long sidelines comments, which was not agreed with the president. Sorry for this. Let me now hand over. Right, that's a very good comment on the sidelines. Let me pick up on it and continue. There's an analogy. This is a criminal organization, a criminal system, as quoted by the member of the parliament. There's the secret service of the communist Poland also used a network of informers. And who is using a network of informers today? Well, the medical chambers.
Taki system mamy.
This is how it works. This is the system we have. Thank you, Agnieszka Kutylowska and Justyna Socha, for your contribution, and Mr. Tetela. And now let's use the opportunity provided by technological edge, and we're moving towards the Green Island, and we go to Ireland, where we have our another guest, Dr. Cahill. Professor, are you with us? Please take the floor.
Can you hear me okay?
Tak, słyszymy. Słyszymy doskonale i widzimy.
Doskonale.
Perfect. Great, it's lovely to be with you. Is it okay if I share my slides?
Czy slajdy będą
Tak,
widoczne?
prosimy.
Yes, please. Yes, please. You can share your screen.
You can just tell me if you can see it okay as well.
Tak jest. Tak jest. Obraz pani komputera jest widoczny na naszym ekranie.
Is that okay?
Doskonale.
All good.
Yes, perfect.
Perfect. Thank you. So, the title of my talk today is Law versus Legal. Do you want to translate, or is it okay for me to go on?
Tak.
Please go on, because you are interpreted simultaneously.
Excellent. Thank you. And so the next slide, it's a little bit slow coming up, is my computer has frozen. But anyway, I'll just give you a little bit of background. I'm a professor in immunology, and I was 20 years or so researching and developed technology that was able to assess autoimmune diseases and cancer. But one of the applications would be to look at adverse events of reactions to the vaccinations. And that was something I was trying to retire in 2017 in order to study that. Now, I'm afraid my computer is a little bit frozen. I don't know why. That sometimes happens. And since I basically have been researching since 1996, and I read what was going to happen, exactly all the plans have been written down. And 25 years ago, they were planning that the years for the most deaths would be between 2020 and 2025, 2026. So because of that, I spoke up very early in 2020, and I'm very honored to have built worldwide organizations, including the World Freedom Alliance, the World Doctors Alliance. We have over 135,000 involved in that. Freedom Travel Alliance that supports our freedom of travel. We have 100,000 subscribers to that. And I was involved in developing the PCR sequencing consortium with colleagues in America, IPAC Knowledge, And I'm also associated with many networks around the world. And I had a radio show coming out of Australia, and I have been viewed over 2,000 million times in 2020 and 2021, my videos. And then I'm completely censored from social media since the middle of 2021. And maybe, can you hear me okay? Is everything all right?
Doskonale.
Yes, it's perfect. We can hear you. It's great. Please continue.
Great. So I think one of the reasons why I'm so censored is that the presentation I'm going to give today is something I've been working on for 20 years. And I think my message is that in fact we can solve and push back what is going on. It may take us 2 years or 10 years or a generation, but we are really the first generation in history that have access to enough information to figure out and study what is going on and then solve it. So that's what my presentation is today. So I want to give people hope, and why I spent from 2020 traveling to make contacts and networks around the world is, first of all, to ascertain, as was mentioned previously, who are the true freedom fighters, because I would say about 80% of the people who are putting themselves forward to be on the side of freedom are actually saboteurs. So what we've done in our networks, in everything I'm involved with, is to provide information to determine how the sabotage works. So, for example, the sabotage might work by somebody saying that they will support a particular group or a rally, but then at the last minute they undermine the websites, or they sabotage key elements, or they try within different nations to undermine people that their sabotage network, essentially who are implementing the assault on our lives. And so that's actually a very important part of the last 3 years. And it's using this information in order not to have this phase, the solution phase, to be sabotaged by infiltrators. Now, apologies, my computer. Sometimes when I'm speaking, my internet suddenly gets slow. So part of the solution is for people to remember in the talk is, in order for us to reveal what is going on, it only takes one example. And I'm just going to give you, it just takes one example. So for example, I was involved with the Baby Will case in New Zealand, or I just got a phone call this morning that in another nation, a nurse who lawfully and peacefully was giving information about adverse events has now been imprisoned and is being medicated. That I've only found out about this morning. So it only takes one example of someone harming someone that we manage to apply the law to whoever does the harm, is how we can then call that a precedence case. And I suppose my key message is, it doesn't matter if you are dressed up looking like you are a police, or you are in a room dressed up as a judge. That doesn't make you police or judge. What makes you a police or a judge is that you are acting under the law and you are not yourself engaged in criminal behavior or misrepresenting the law as fraud and deception. So how the solution works is that if you have a case, so for example, the case in New Zealand, or this case now of this nurse, we don't even need to know the law that well. we just need to ask the question, we'll say in this case of the nurse, whoever actually touched her and infringed on her bodily integrity and coerced her or assaulted her and brought her to somewhere and then medicated her without her consent, were those people acting lawfully? Or were they engaged in criminal behavior? And I guess the real key question is, were they acting in the law or were they acting in the legal system? And what is the difference? And I suppose another way to think of this is really what is going on, right? What is going on? And then the second question is why? And part of the solution is if we don't actually know what's going on, we can't solve it. And there has been a process for many hundreds of years in order to deceive or make it difficult for people to have knowledge that would allow them to push back on what's going on. And as I will show to you, essentially what's going on is fraud or deception. And the fraud or deception that's going on is a misrepresentation of the true law using the legal system. And what I found is that people find it hard to take in unless you can prove to them that there is deception going on. And where did this deception start? Now, it turns out that it started more than 2,500 years ago, which may be hard for people to come to terms with. But some specific examples of the beginning of the deception is that Cardinal Thomas Wolsey, who was cardinal with Henry VIII for 15 years, he explained exactly this deception of the law, and he called it learning against learning. So what basically they are doing is they are, through the education system and all elements of society, they are giving false information. And in fact, the information that they're giving is the exact opposite of the truth. And the aim is that if you have multiple generations of people over hundreds of years who are all only told false information, they will never be able to figure out the deception and the lies. And there's a quote from over 100 years ago saying that the lie would be so big that those who figured it out would be thought insane. So as we know, Thomas Wolsey was presenting himself in the church and he worked with the monarchy. And there are three elements of the fraud that's going on. And they were called the black nobility, because black is essentially synonymous with something that's evil. It's not that they were actually had related to the color of their skin. So the black nobility, or this process, involves the Vatican, the city-state of the Vatican, the city-state of London, and the city-state of Washington. And the London city-state operates the criminal and unlawful financial element. The Vatican actually holds the criminal and unlawful financial instruments that are created on everybody, called a trust, that we know as a birthing certificate. And then the military component is in Washington. But another historical figure, Ignatius Loyola, in 1541, he was saying that what they would do in the Jesuit system is, and they had 18 points, but point 13 was that they would ensure that people would learn exactly the wrong thing. So that they're saying, if we say snow, white snow is black, then it is black. So in more recent times, it has been synonymized with 2 + 2 = 5. So essentially there is a process to give false information to people. And the false information in this talk is presenting the law falsely, misrepresenting through the legal system. So then this is just to say what is going on. So this is in a clinical trial. If you have one death in the trial must be stopped in the law. And the reason for that, because every man and woman, boy and girl, have a right to life, which can never be taken away, that whoever is responsible for the clinical trial that does not stop it, they are criminally endangering the lives of people, and the people involved in the trial and the people dressed up as police and the judges and Supreme Court judges, because they omit to do their duty in law to save lives, they hold the liability in law for the death of those people. And so the names for that are contributory manslaughter or murder. And so in the law, we have over 30,000 deaths on these trials, and we know there is even more deception by failing to properly count. And there's over 1.5 million reports of adverse events. So this is what's going on now. But more recently, what we saw in New Zealand, and I was very honored to be helping with the New Zealand team, is we saw that a mother had 2 beautiful twins, and there is a hierarchy of law, and the right to life of men and women, boys and girls, is higher than anything written down. And men and women, boys and girls and babies have it all their lives. It can never be taken away. So the right of a mother to protect her baby is in the natural law, and that is higher than anything written down. So it is higher than all constitutions, all treaties, all acts, statutes, guidelines and regulations. And this right to life, right to protection of a mother and father and their boy and girl can never be taken away and can never be given up. So anyone interfering in that right and misrepresenting the law, as we saw in New Zealand, is engaging in fraudulent misrepresentation of the law. And why the solution is straightforward is because here you saw what happened in New Zealand. This is in a way the culmination of the hundreds of years of this deception, where they are trying to impose a legal system over the law and misrepresent it. And you have a woman here who is removing a baby to do a medical procedure absolutely without the consent of the mother and father. Now, this removal happened when the baby was deep in sleep around 11 o'clock at night, and the baby was going for surgery where in the legal system, a judge said that the legal system and corporations or businesses within the legal system could override the decision of the mother and father around their protection of the inalienable rights. So this is actually what's going on here. We have to ask ourselves, is this lawful activity or is this unlawful? And the simple solution that you just have to ask a simple question. The woman that is taking the child, does she have a right in law to do that? And how you determine that is this woman and also these men who are interfering with the mother. They literally were threatening to arrest the mother, and the father is also in the room. Are they operating as individual men, as policemen under the law? or are they operating in another role? So the simple question we can just answer is, what is the employment status and how are they operating? And so, first of all, let's look at where does the right of the mother and father and the baby, where does that sit in law? And in law, there is a hierarchy of law, and this is part of the knowledge that they have been hiding from people. And when you talk to many people who are in the medical and science and political level, and in the system, the legal system, they say they are not aware of it. But part of real fundamental truth is that this aspect of the hierarchy of law is not just me, Dolores Cahill, saying it. This is actually true and has been true for hundreds of thousands of years. So the natural law is high up in the hierarchy of law, and it comprises, very simply, this is the entire natural law. So the entire law can be summarized in act in honor, do no harm. And also that men and women, people who are alive, have an inalienable right in law to right to life, right to travel, speak, privacy, and private property. And that is essentially the law. And any harm that is done that constitutes a criminal offense is harm done to a living man or woman, boy or girl, or people, and that is the law. So what we see that happened in New Zealand then was, where is the decision for the right to life of the baby? So this baby needed heart surgery, and the mother and father wanted to make decisions in relation to a blood transfusion, that it wouldn't be from a injected or vaccinated man or woman. But really, that in a way is irrelevant. It is around who has the ability to make the decision. So essentially it is the rights of a mother, father to protect the right to life of their baby versus some strangers to the family that are interfering. And are they operating in law? So what we found that happened 2 or 3 days ago was that a man or woman dressed up as a judge issued a written document to say that he and his agents had the jurisdiction to take the baby from the family. And it turns out that I was involved with other colleagues in Freedom Travel Alliance to get top consultant doctors in America to write and say their professional opinion that the baby did not need this operation for weeks. So this, we have a stranger to the family saying that take the baby away and do an open heart surgery, potentially with injected blood, that the mum and dad didn't consent to. And the reason why, of course, in the natural law, the mother and father have the right to make these decisions is that even if the mother and father have the best intentions, if the baby is harmed, we'll say lifelong harm, it is the mother and father that will dedicate the next 20, 30 years of their lives caring for the consequences of the operation. Whereas this stranger that has no relationship, like the woman removing the baby, she will not have to manage whatever the consequences are. So part of the thing about law and natural law is that it resonates in truth. And that once people think about it, that of course the structure for hundreds and thousands of years is that it is the mother and father that have the right to protect their elderly parents or their children or themselves, and no one else in law. So that is the effect of the law. So also in the natural law, in the hierarchy, the inalienable rights to life, travel, speech, privacy, and private property is above all written documents. These inalienable rights, inalienable means can never be taken away, is above all constitutions, acts, statutes, regulations, and guidelines. And these rights can never be taken away by anything. So any act around COVID-19 or any other thing written down can never interfere with these rights. And if you do, it is a misrepresentation of the law. So what is the difference then between the law and the legal system? So here you see we have law versus legal. And the difference is that you have to be alive for the law to apply. And in the legal system, only applies to things that are not alive. And so this subversion of the knowledge is that all around the world, people talk about legal and illegal, and they think that legal means lawful and illegal means unlawful, but they are two entirely different things. It's like if you have a Venn diagram in maths. The legal system is one thing, the law is a completely separate thing, and there is no overlap. So the legal system only really applies to what's called dead entities. And the other word for that in the legal system is a corporation. And corpse is something that's dead, and corporation is a dead body speaking. So all of the analogies in the legal system is to do with death, and the judges wear black robes because they're only dealing with things that are dead. So when we have an issue around medical treatment, all medical treatment, because it is applied to men and women who are alive, you can only operate in the law. So if you hear someone talking about legal or illegal, or the legal system, in a process where they are determining medical treatment, like baby will or adverse events, that is a misrepresentation of the law. And if you are dressed up as a judge or police and you misrepresent the law, there is a special name for that as a criminal offense, and it's called malfeasance or criminal misconduct. And it is the second highest crime in all of our nations. And in the United Kingdom, for the man dressed up as a judge, it's 20 years in prison. And in Ireland, for police, if they are not operating as police, it's 20 years in prison. And so all you need then is one case. So you can look at the people dressed up in that hospital room and the woman that took the baby. And you can determine in the law, using a trial by jury, so it may not be that case, but we also have this nurse now that's locked up against her will, exercising her right of freedom of speech to give information around the adverse events of the injections, which are true. So we just need one case in the world to look at who was the man or woman who touched the baby. Were they acting in the law, or were they acting criminally? And if they are misrepresenting the law and taking a baby away, and that's a criminal offense, that is then unlawful detention. And any subsequent treatment to the baby by the surgeons and breach of the skin is actually endangering the life of the baby without consent, which is one of the highest crimes, and also misrepresenting the law. So the very quick thing then is that the law applies to men and women, boys and girls and people. It's very simple. And usually if you autograph in the law, you autograph in red, and that's as a symbol of that your blood is there, you're alive. And the legal system is always written in black, because when blood is left for some time, for people will say who are dead, the symbology is that that it's black. And also it's written in all caps, because when on your tombstone, when you're dead, the letters of your name are written in capital letters to symbolize that you're dead. But also in law, in most of our countries, we'll say in Ireland, it's the language of the law is English and Gaelic or Irish. We'll say in Poland it would be Polish. But the legal system has a completely different language called legalese. And if you are written documents, we'll say in Ireland, in English, that is lawful, or in Poland, as in Polish. But if you are written documents in legalese, which is a foreign language that has no standing in law and is another criminal offence of misrepresentation of the law, it's issuing a counterfeit, which makes the document unlawful. So that's, for a very simple case, we could just analyse what the judge wrote in New Zealand, and was that document written in a foreign language that has no standing. And how you know that is if you have names in all capital letters, more than 2 in a row, on that piece of paper that is not in the language of the law and is issuing a counterfeit and has no standing, and that judge then can be investigated for misrepresenting the law while dressed up as a judge. So the knowledge then that we are trying to give people is that if people dressed up as police and judges are misrepresenting the law, that is the crime of fraud. So in Ireland, fraud is 7 years in prison. There's also no time limit on fraud, and no one is above the law. These are maxims of law. So fraud unravels all. There's no time limit, and no one is above the law. So it doesn't matter if you're a Supreme Court judge or any of those people dressed up as police. Everyone, there is no so-called immunity from prosecution, and the law works by trial by jury. And I think what's very positive is the law operates wherever men and women are alive. It has operated for tens of thousands of years. And then how do you hold people to account? You do it in a trial by jury. And you don't need, for the solution in we'll say, the next 10 years or the next generation, it is not that we will be looking at one big Nuremberg case. Once people realize that trial by jury is lawful, they can then have trial by jury everywhere in the world. So whether it's in New Zealand, in the where baby Will lives, or whether it's in Ireland or whether it's in Poland, and the law applies to all men and women now. And this law about protecting the right to life, because simply you can't go around murdering people. You know, if you were just to think about it, how our societies have developed. And if somebody started to kill babies 1,000 years ago or 3,000 years ago, the community would get together and stop them. And that's because they know the law, and there was an oral tradition of the law. So then how does it look like? This is actually the law, and the natural law, which protects the right to life, is the highest in the hierarchy of law. And then below that, you have men and women, and then the men and women are people. They bring in written pieces of paper, but the written pieces of paper, like the documents that constitute the government or legislation, statutes and acts, are all below. And in the hierarchy of law, and this is very well established, in law, nothing lower down can interfere with something higher up. So your inalienable rights to life, which include bodily integrity, and a full and free informed consent is higher up, and inalienable rights to travel, speak, privacy and private property are all here. Nothing lower down and nothing written can interfere. And again, you have a hierarchy here. So where you see, if you had a guideline or a regulation, that could not interfere with the lawful statute. And if you had a lawful statute, that could not interfere with the Constitution. That's lower down. But it's the same principle that no constitution or no statute or act, guideline or regulation can interfere with something higher up, which is your inalienable rights. And also there is a special onus and responsibility for people who are employed. They have a more duty to uphold the law, and they are called public servants. And so this is why the crime of malfeasance, which is the second highest crime below treason, is reserved that if people are dressed up as police or judges and they engage in criminal activity and misrepresent the law, it's essentially lifetime in prison for them. And if you have one trial by jury that shows that a man or woman dressed up as a judge criminally misrepresented the law, endangering the right to life of anyone, then they can be held accountable, and that is a precedence case in law. So what they've done is essentially switch it. Now, there is a history as well of this, but I don't know if you want me to go on, or are you happy for me to stop there?
Dziękuję serdecznie.
Thank you very much for your contribution, Professor Dolores Cahill from Ireland. We have another guest waiting, so maybe we will move towards our second guest from France. Diane Protat will continue, a lawyer. She will present the topic related to the acquisition of vaccination against COVID-19 by the European Union. And here I have a question. Coup d'etat of the European Union against the member states. Diane Protat, are you with us online directly from Paris? The floor is yours.
Lovely.
Yes, do you hear me?
Słychać i
Doskonale.
Yes, we're going to hear you perfectly. Thank you. Yeah, please go on.
Well, first of all, thank you for your invitation and to let me speak in your House of Parliament about this COVID contract. I will start getting back a little. You know, I remember when I did my first year of law school. It was the time when we had euros for the first time. And I remember I was eager to go with the Erasmus program, visit all the country of Europe and paying with my euros. It was the first time I went to Poland, for example. And we were really happy as young students, and we learned about the laws and the EU regulation. And after 4 years of law school, that was the end of my formation, but it was also the time of the Treaty of Lisbon. I don't know if you all remember, but in 2005, this Treaty of Lisbon was supposed to change the architecture of the European Union, and French people, as well, if my memory is correct,
and Irish,
Netherlands people, and Ireland also,
and Ireland, yes. Yeah.
They vote against it. People vote against it. And we still got it. This is a real problem. This was, in my opinion, kind of the first coup d'etat of the European Union, because as a law student, it was the opposite of everything I was taught by my teachers. I did not understand, but I still keep on going. I took the oath as a lawyer, and I still looked at the European regulation. But 10 years after, it turns out that with the COVID crisis, and now maybe also with the Ukrainian conflict, that the scope of the European Union powers, as well as the Commission, are growing a lot, but without the consent of the people and without the consent of the member state. And this is very important. And the contract that the European Commission made about the vaccine against COVID-19 is an example of that. And this is what I will try to explain. First of all, in the European Treaty, the Article 3 says that health is not a matter that should be dealt by the European Union. Health, the matter of health, lies in the hand of every member state. And this is what the treaty says. And in the case the member state cannot handle all this health problem, well, in this case, the European Union can intervene, but it's not supposed to do so. And with the COVID crisis, the European Union, in order to buy this COVID vaccine, well, gave the Commission a special mandate, an emergency mandate, to start negotiating the purchase of the vaccine with different laboratories, with different pharmaceutical companies. So at the first, under the emergency protection, if I may say, under this label of emergency, well, they gave more power to the European Union to do this contract. But it was not so. Emergency power should last until the emergency lasts. So this is a real question, because today we are still talking about an emergency in Europe and in the world about the pandemic, but it's not true. So all these powers that the Commission gained, the European Commission gained through the crisis of COVID-19 are supposed to stop, but they are still using it and under the circumstances of the emergency that do not exist, in my opinion at least, that do not exist anymore. But with the special power under the emergency, the European Union, the Commission especially, conclude what was called an advance purchase agreement for billions and billions, and it was in November 2020. So for this first advance purchase agreement, well, with the emergency mandate, well, the Commission did have kind of power to do so. But after this advance purchase agreement, two other contracts were signed by the European Commission, one in February 2021, another one in May 2021. With these two other contracts, well, the European Union bought more and more doses that maybe we didn't need, at least. But what is very, where the problem lies is for these two last contracts, well, the Commission didn't have any emergency mandate. They didn't have any mandate to pass it on. So it's, for the Commission, a tremendous violation of the treaty to purchase this vaccine with no authorization. And this is the same system that is used for the weapon that we bought for Ukraine. But this is another problem. That's to make you see how under these emergency circumstances, the scope of the power of the European Union through the Commission is enlarging, and but it's a violation of the right of the people. And what we can see also, this is very important, is that with the European Commission act with no mandate, but also maybe committed act of bribery by purchasing this COVID vaccine. Maybe you all have seen that now the European public prosecutor launched an inquiry on the acquisition of the vaccine. They made a brief, they made a communiqué de presse. They made a statement by the prosecutor office saying that under the public pressure, they were forced to open this inquiry in France. We launched this initiative. We asked the people in France to send requests to the European prosecutor to open this inquiry, because we all know, and it was in the New York Times papers, that Madame Ursula von der Leyen did send lots of text message to Mr. Albert Bourla, negotiating with him the contract on her own. And this, as all the European citizens, through the European Ombudsman, ask for this text message to be released, because we believe that these text messages are part of the negotiation of the contract and they are public. I myself, for a French association named Bon Sens, we are challenging the contract in front of the French jurisdiction. I would say between brackets that this contract says that the jurisdiction and the law that should be applied to these contracts are Belgian law. Not even the law of Luxembourg, the Court of Justice of European Union. The law, what should apply is Belgian law. This is a fraudulent, this is forum shopping. This is a fraudulent way to attach a case to a country. There is no reason for the Belgian law to apply for a contract that is between, for example, Italian state and Pfizer. There is no reason for that. And so we are challenging it in France, and we challenge it also because under this contract there is a clause where Pfizer is indemnified by every state of every possible consequences of the side effects of this vaccine. Pfizer, who is the manufacturer, should be the one paying for the side effects. It should not be the state and each one of us. So this clause by which Pfizer is not liable is a total violation of all the contract law of all our state members and everyone can understand that when you sell the product, well, you should be liable for it. There is no reason it's not the case. And moreover, everybody knows that the European Union gave money to these pharmaceutical laboratories to develop the products. So we gave them money to make them. We are paying for the side effects that these drugs are given. So this is not a normal way to use the money of the European Union, of the European citizen. This is absolutely abnormal. But if we go into that, we are asking with my client in France for the text message extent that we were talking about, that were exchanged by Ursula von der Leyen and Mr. Albert Bourla, because we believe that inside of it there is this bribery pact, and this text message will maybe explain why on earth the European Union accepted these terms of contract, which is, in French, we will call it léonin, which means that this is a contract that is very, very bad, and for one of the parties, and the party for which is very bad is the European citizen. For Pfizer, it's a very good contract. They pay nothing and they win lots of money. And this is why we need to intervene and to have this inquiry. We need to understand why the president of the Commission, Ursula von der Leyen, allows herself to sign such a contract on behalf of the European Union. And when I say on behalf, it's not on behalf, because we have because she had no mandate. And while we were thinking of all these cases, something very interesting happened. Well, and maybe people have seen that too, but Albert Bourla was called by the European Parliament to come and explain himself about the text message, to explain himself about the way these contracts were negotiated. And he didn't come. Instead, he sent a representative of our company, a woman named Janine Small, and she was asked questions by some European MPs. And she had two very interesting answers. First, when she was asked about the text message, she said, "Oh, I know there was lots of text message between Albert Bourla and between Mrs. Ursula von der Leyen, but they are purely private." As a lawyer, I have some doubt about it. Maybe there is a love affair, I don't know. But when you're exchanging 100 of messages, and if you say it's probably private, as I said, it means that they are very tight. But in my opinion, of course, they are not private. These are public documents. These are part of the contract, and we all need to know what's inside of it to understand it. But Madame Ursula von der Leyen would not give it to us, even though the European Ombudsman asked her to do so, and even though the European Ombudsman said not giving this text message is a maladministration for the European Union. So even though the European institution is asking Madame von der Leyen to give these messages, she doesn't do it. So we should all ask ourselves, how come this person, who is supposed to be the president of the Commission, is thinking of herself above the law? And we might have an answer, because if maybe you have seen, but another commissioner, a European commissioner named Sandra Gallina, was in charge of was the head of the negotiating team of the European Union to buy the vaccine. And she made a declaration in front of a European MP named Rob Ross. And this woman, as I said, Sandra Gallina, she's the Director General of Health, and she reports directly to Mr. von der Leyen. And she says, I'm going to read it because it's her statement. She says, "It's sometimes an easy alibi to say, I don't have the competence. I don't do it. If you have Parliament behind you, you can do a lot of things. So it's a little more nuanced. But of course, if you have it in the Bible, my legal colleagues tell me, in the treaties, it said this and that, so you can't do it, Sandra." Basically, most of the time, that's the answer. So I said to my colleague, I don't care. The people want it, well, fine, we'll find a way to do it. And it's for the young people. It's very motivating. Let me say, because it's not right. So I know it's a very heterodox way to do things, but it's the way to create Europe. If you create Europe only by following the text, we will stay there. I hope it's understandable for everyone, but this woman who is in charge of the negotiating team for the vaccine, who is also European Commissioner, is saying publicly in front of every citizen that she doesn't care about the treaties. When her legal team says to her, well, you cannot do that regarding the treaties, she said, I don't care. I want to move on and to create Europe. But this is a tremendous problem because in the treaty, the European Commission, has no power to create law. He is there to implement the treaties, to monitor the treaties, to see that every member state are applying in a good way and good faith the treaties. They are not there to create the law. European Commissioner is not the presidency of each of our member states. They are not there to create the law for us without our consent. And now when we see this declaration, when we understand that this European Union that we are supposed to love, when I say as a student, I really love to travel to Europe and I feel myself as a European person, and this is why I'm here talking with you. But of course, I don't follow this legal advice of this woman saying that she will create law with it, even if she doesn't have the power to do so. And this is where we can all think that this is a kind of a coup d'etat. When the Commissioner of Europe is all saying that they won't follow the rules, when they are asked to also give their private messages to show the transparency that the citizens need, when they refuse it, well, they are still working at the European Union, and this is not normal for all of us. And what we see with this crisis is how this European Union violates the member states, violates the democratic principle of all of us. And in my opinion, this is where we should, I hope, I will say that this way, I hope we will really have courts of law who will declare this contract void, because accepting this contract is like accepting that we all of our governments, all of us, lost our freedom, lost our right to participate to the democracy in each country. When people vote, it's because they all have a part of their citizenship, they are all part of the country. If the country becomes undemocratic, well, we as citizens, we should not agree with that. We should fight against that. And the first step is to make this contract void, because if we accept that with emergency motive, with all an emergency that lasts for years and for years and for years, that if we accept that it gives the European Union powers that they shouldn't have, well, we will at the end have no freedom anymore. As I said, this mechanism that was created for the vaccination, to purchase this vaccine against COVID-19, is the same now that is used to buy some weapons to fight to help for Ukraine. So this is not what the citizens want. I believe we all want Europe, but we don't want a Europe with no freedom. It reminds me, in a way, and if I can say the words of Margaret Thatcher, at one point she said, I want my money back to the Europe. And I believe we all should say that we want our freedom back. I think this is the time for all of us, and I think all the lawyers in every country should challenge this contract of purchasing vaccination and say that and make the trial in their own country, as we did with the Bon Sens Association. Maybe you know that the president of Bon Sens Association is the Professor Christian Perron, which is a great doctor fighting for all of us, fighting for our freedom of speech, or freedom
Diane, we'd be very interested in doing it in Ireland. We have re-established trial by jury under the law,
And I think I will circulate the claim, because the claim will be pleaded in France during this December. Maybe we will have help coming from other countries, but we have to say that this contract should not have as a jurisdiction Belgium law. This has no sense, since the Commission buys all these vaccine, and then each member state, through vaccine orders, is paying for his own vaccine. It means that each vaccine order form should follow the law of its country. For example, vaccine order form in Austria should be under Austrian law. So I invite of my colleagues and lawyer to make this trial under their own country, because we need to say to our judge, now it's over. You cannot apply contract from the European Union which has no mandate to close it.
Yeah, just one quick thing. All this health thing applies to men and women, and citizens are just business corporations. They're not alive. So we all have to use men and women, because the health thing is all in the law. So citizens are just this corporation, So we have to, all of us, learn. It's a revelation, right? That all harm and vaccines that are bought are only bought for men and women. And citizen is this business entity. So that, and the law doesn't apply to citizens. You know what I mean? For all of us.
Yes.
We actually have re-established trial by jury in Ireland under the law. And Diane, I know we're in touch. I would be very happy to get access to your information in order to put a investigation of fraud for this case.
I will circulate all this because what we say under the law is that saying that the Belgian jurisdiction should apply is a fraudulent jurisdiction, and this has no explanation. So we should have our laws back in each country, and I will circulate. And I'm happy to know that everyone is fighting for that too.
Absolutely, I support you. You're doing amazing work.
This presentation has not been that long, but I thought it was very important to emphasize that the power given to the European Union through this contract is something that we should not accept at all, because it will repeat. And once we gave all our freedom to the European Union, nothing will be left for us.
And I just wanted to follow up what you're saying. It looks like just today it's reported that the Belgian police have arrested for corruption in a different issue, including one of the 14 vice presidents of the European Parliament. So that might be interesting for you.
I've seen that this morning, and I think it's very, very interesting. But I will not make some comments about it. But I think it's the beginning of something. At least I hope.
It's a precedence,
I hope.
Well done.
First, it shows that they are not invulnerable. They are subject to law, and they can send to custody, they can send to prison like all other people. And this will give all people a feeling of strongness.
But you will have seen something, that this is the Belgium jurisdiction that are acting against these people. If I may say, the European prosecutor that launched this inquiry, I'm the lawyer of some MPs who asked the prosecutor to launch this inquiry. This inquiry will end up for the prosecutor to choose a jurisdiction. But he will have to choose which jurisdiction will be used. But what a doctor did in Belgium too is, with my help, he put a claim against Madame Ursula von der Leyen, also under the Belgian law, saying that she made a coup d'etat by purchasing this vaccination. So you have claim coming from above, but you have also claim coming from down, from the citizen, and this doctor is...
No, from the men and women, right? In the law, we don't use citizen. It's actually men and women, because they can claim, that a corporation, because it's a business, the citizen, that they are not subject to fraud, right? So if you want to make a trial related to fraud and corruption, then no one is above the law, whereas the legal system puts them into businesses when they're not alive. So therefore, the law, it's like a little, bubble, because they're dead, but of course they're not dead. And Ursula is liable, so no one is above the law.
No one is above the law, but you will have the pleasure to say that if there is an inquiry by the European Prosecutor Office, there is also one that has been launched by the King Prosecutor of Belgium against Madame Ursula von der Leyen, because, as I said, for one part, she made negotiation with Pfizer without any mandate, and in Belgium law, when you don't have any mandate, it means that you are acting instead of the government, of the Belgian government. This is what I meant with the coup d'etat. She shouldn't, when she negotiated this contract, she took the place of every of our government, and she should not have done that. So there is two complaints going on, two investigations going on, one from above and one from under. And I hope all them will at the end be successful and give the transparency that the people deserve on this vaccination.
Yeah, but I think the thing is what we have to do, you know, when you use her title, Madame, you're putting her into the legal system, and when you use words like citizen, you're putting everybody into this corporation. But the legal system actually only applies to businesses on the ocean, trading, in commerce. But Ursula, so if we want her, fraud unravels all, but it actually, the area that we need to operate in is in the law. And so we have to not use Madame, because that's the legal system, and not call her a citizen. She's a woman. And then if a woman is accused of fraud, no one is above the law as Ursula. That's the difference. And that's where the power is. And in the law, everybody has freedom. They can never be taken away. So we're not getting our freedom back. What we have to do is just reveal, it's like the emperor has no clothes, that they have been trying to misrepresent the law using words like citizen and Mr. with the title, but that's actually fraudulent misrepresentation, which is a criminal offense. And so all of us have to use Ursula. The woman is subject to the law, and if she's engaging in fraud, she can then have a trial by jury as Ursula, the woman, and not mention words like Madame or citizen or person, because that puts it into the maritime legal system, which is proper.
Podpisuję się pod tym postulatem jako...
I confirm, as a monarchist, I would rather die as a subordinate rather than a citizen. So I have my reasons for which I strongly support your view. I'm happy that before our eyes we can see an intensification on an international level in the fight against the COVID-related unlawfulness. I'm happy for your presence here, and I strongly encourage you to listen to Dr. Marcin Sowiński, who is with us here in Warsaw, and who is present in flesh and blood here. So could you please announce him? Of course, with great pleasure. I'd like to welcome on the stage Dr. Marcin Sowiński and his speech on the unlawful actions taken by the Council of Ministers in Poland.
I jeszcze raz witam serdecznie.
Once again, welcome, and I'm sending warm regards to all speakers abroad and to all the audience. Can we launch the presentation, please?
Ja chciałem się odnieść.
I'd like to refer to the Polish legal system, and it will be close to what was said by Georg Pachlik, as I will refer to the actions taken by the Polish authorities and the evaluation thereof by the courts. So they exercise the law as if they were operating out of the Polish parliament, because the parliament in Poland is also adopting acts of law, but the Minister of Health or Prime Minister issued their orders and ordinances as executive bodies. So in Poland, we have several hundreds of decisions of administrative courts, and pursuant to the Polish law as of today, they are competent to evaluate the compliance of the acts of law with documents like ordinances. And today I'd like to present a series of ordinances which were subject to decisions of administrative courts in Poland. And then after the sanitary authorities appealed to the Supreme Administrative Court, I just want to tell you that all these court decisions are binding and effective and final at the level of Administrative Court or the Supreme Administrative Court. So these decisions regard some cases of people who were harmed because of illegal actions taken by the sanitary authorities in Poland, who imposed penalties worth of 30,000 PLN or more, and sometimes many times. So people who appealed in court, their appeals are effective with over 95 or even more %. So they were managed to prove that these penalties were unlawful. So these were cases brought against the men and women of Poland and against all of us who were harmed by that, because many of us were harmed. Okay, as we have the presentation, I can see that not everything is here. So we have the ordinance of the Minister of Health of 13th of March 2020. Łukasz Szumowski, the former Minister of Health at the time, who has been devoided of his parliamentary privilege as he resigned from it, so he's available. So let me point out that he signed 2 ordinances, and these 2 ordinances were proven to be unlawful. We have 3 court decisions from the courts in Gliwice and 1 from the Voivodeship Administrative Court in Warsaw. And here I want to refer that in one of decisions issued in Gliwice, signature 391/20, there was a complainant lodging against the sanitary authorities with a complaint that he was submitted to a quarantine with regard to crossing a border of Poland. So the court was considering that, and how can we penalize somebody who was in contact and somebody who was not ill. So the administrative court repeals this concrete decision taken by the Polish sanitary authorities and redeems the procedure and force the sanitary authorities to return the financial penalty, the fine, and additionally the administrative courts in Poland returned the court fees and the legal cost and imposed an obligation on sanitary authorities to return the fine. We know that there are many similar cases underway, so everyone who was harmed by something like that can appeal. So documents are available. And what's even more important, and here I will jump to another slide, the complaint is justified, and let me just quote a few sentences, a few quotes from decisions. This complaint was substantive, because decision issued by the sanitary authorities were issued This ordinance was issued, and it was just the introduction of the epidemic emergency, the state of epidemic emergency on the territory of the Republic of Poland. And this ordinance, maybe it was in line with the Act on Counteracting Infectious Diseases, but in the catalog of limitations at that time, there was no obligation to be subject to quarantine at all. So here we have the appeal that based on Article 31 of our Constitution, it stems that the limitation in exercise of freedoms and rights established by the constitutions, they might be limited only for the sake of the public order and environmental so these limitations cannot infringe the nature of freedoms, which is confirmed by the Constitutional Court decision. This act must independently determine the basic elements of the restriction of a given right and freedom. Only provisions of a technical nature should be included in the regulations. So many of these limitations, they are not included in the act, and for that reason it appeared as in Austria. But you had if you hadn't any written form, we have a written form in ordinances which were published. Please switch to the next slide. With the introduction of provisions related to the prevention and control of the epidemic caused by the pandemic, the freedoms and rights have been transferred from the law to the regulation. This would be permissible in the event of a declared state of disaster only. And we have such an act in Poland, and it allowed the Polish government to exercise and to announce the state of disaster, and many of these limitations that we have and that we could see, would be possible to introduce them. So it was not possible to implement restrictions which seemed compliant and reasonable for the sake of protection of people in Poland. Everything was illegal, and we have 9 ordinances that I'm going to show you. And in Article 21 and 22 of the law of the state of natural disaster specify the necessary restrictions on human and civil liberties and rights in the event of a state of natural disaster is only possible, but it was not permitted in this particular case. So we have the public officer's responsibility, because all public officers hired by and working in the Polish government, and because very often, on numerous occasions, it was the Prime Minister who signed them. On 2 occasions, it was the Minister of Health, Łukasz Szumowski. So, from the perspective of our administrative evaluation, it was a flagrant infringement to the principles of a law. So the responsibility, the liability, and we are still talking about holding these people accountable. And I think that the time will come, because at some point in history, these people are going to lose their parliamentary privilege at the end of the day. So we know it will be very difficult to go to the truth and to find what was the truth. So that's why I appeal to all of you that if somebody is in breach of law and exercises any public functions at the level of the Constitutional Tribunal or Supreme Court, these people should be devoid of their parliamentary privilege, because we had numerous occasions, and with high probability the court, and this is of course my opinion, that this infringement of Article 231 of the Penal Code. So, no, please switch to another slide. So the delegation contains only the power to establish a temporary restriction of a certain mode of movement, but this is not equivalent to establishing a quarantine obligation, which is equivalent to a ban on movement within the territory of the Republic of Poland for a certain period of time. So it was not possible to supplement an act of law with this ordinance because it's within the competence of the Polish Sejm. When it comes to the act performed on the basis of the executive order so issued, it was declared ineffective by the court. It was issued in violation of Article 52, Section 1 to 3, and Article 91, Section 1 of the Constitution, as well as Article 46, Section 2 and 4 of the Law of Prevention and Control of Infectious and Infectious Diseases in Humans. So the court has specified and has declared all actions like that were illegal. Once again, sentence that both on the date of the applicant's crossing of the state border and on the date of the criminalized event allegedly constituting a violation of this obligation, there was no substantive legal basis of statutory rank or a properly established statutory delegation to regulate this issue. Another important thing, there was no statutory basis for restricting a citizen by ordering him to remain in quarantine, which is a type of restriction on the right to freedom of movement, and an obligation in the regard was established by the Ministry of Health Regulation. Here we have quite interesting content. The courts usually explain their right to decide whether an ordinance is compliant with law or not. So that's why all sanitary authorities. So within the judicial cognizance also includes the assessment of the constitutionality and legality of a regulation as a basic act by a court, considering individual cases in which such a regulation could be applied. So all harmed people can apply for damages. There is a
te rozporządzenia, napisał do Trybunału Konstytucyjnego prośbę o wyjaśnienie, czy
the group action is being prepared. The Voivodeship Administrative Court will decide whether such ordinance is in line with the Constitution. So the Supreme Court hampers the decision, so we can expect that the Constitutional Tribunal will not decide. The Supreme Court undermined the functioning of the Constitutional Court because of substitute judges. So we have complete chaos in the legal system in Poland, leading to preventing such cases from being heard and evaluated. We had 7 judges of the Supreme Administrative Court, and they said that it regards administrative courts under Article 184 of the Constitution and Article 178, the administration of justice by controlling the activities of public administration, which includes not only control of the application but also control of lawmaking by administrative bodies. So why is it going to be undermined by the Constitutional Tribunal, dear Prime Minister? Next slide, please. The adjudicating court fully shares the view expressed in the judgment of the Supreme Administrative Court in Warsaw that Section 4 of the 13th of March, which are no longer enforced, but which was the basis of the authorities' adjudication, are unconstitutional because of substatutory provisions they restricted. Okay, next slide. The second ordinance of the Minister of Health of 20th of March 2020 on the cancellation of an epidemic emergency on the territory of the Republic of Poland. Here we have the case number 30,000 PLN for violation of the obligation of quarantine, which was adjudicated illegal. So a natural person was penalized with a fine of 30,000. This person has to incur 4,500 PLN of legal and court cost, which was, of course, borne by the sanitary authorities. So they will need to explain that before the regional public prosecutors. Such people are invited to the public prosecutor's office in order to explain what they did at the time. Another judgment issued by a panel of 7 judges of the Supreme Administrative Court stating that the allegation that the Administrative Court is not competent to assess whether a provision of a regulation is consistent with the law of the Constitution of the Republic of Poland and cannot refuse to apply a provision of a regulation on the grounds that the provision in the court's opinion is inconsistent with the law and the Constitution of the Republic of Poland is not correct. In this regard, there is no collision between the competences of the Constitutional Court and the Administrative Court. In the present case, the Voivodeship Administrative Court of Warsaw recognizes that both paragraphs 2 and 3 of the Health Minister's Order of March 2020 are unconstitutional because as sub-statutory provisions they restricted contrary to Article 92. In the court's opinion, regardless of the evaluation of articles this and that of the law on the control of infectious diseases, the Minister of Health did not have a correct legal basis for issuing a regulation causing a restriction of citizens' constitutional rights and freedoms. So the statutory authorization cited by the Minister of Health did not provide at all for the possibility of establishing a quarantine in the regulation. Also, another appeal decisions allowed to conclude that to the refusal to apply the health minister's regulation. So we have a few dozens of thousands such litigations, so lawsuits, and several thousands were cancelled. So it is stressed everywhere that these were sanitary authorities' decisions. Out of these 85% of Poles, many of them were not legally based, so all these people should be reimbursed their fine, and that should be a mass action. So there are attempts to justify some illegal decisions who, for example, revealed PESEL numbers. People were waived from their liability and with a reverse effect. So this is a precedence in the Polish law. The above description violation by the authorities Article 6, 7, 8, 12, 61, 77, 81 of the Code of Civil Procedure do we know how significant this violation was? It was exceptionally flagrant violation of procedural law, which also constitutes grounds for invalidating the contested decisions. So please note, without any verification what happened next, it became an evidence and legal base for a fine without any legal trial and explanation. So the nature of infringement, the person was deprived of any opportunity to defend them in the proceedings that ended with the punishment of a severe fine. In both instances, it was like inquisition, and I'm reading. So in fact, the proceedings of the authorities of both instances were inquisitorial in nature, rather than proceedings conducted to properly establish the facts, allowing the party to present its procedural position and possible evidence in the case. So it was like inquisition back in time. Let me protest. Inquisition was, Inquisition had some solid evidence. It is a black legend against that. We understand that the court operated in good faith. Ordinance of the Council of Ministers of the 31st of March 2020 on the establishment of certain restrictions, orders and bans in connection with the occurrence of a pandemic condition, signed by the Prime Minister Mateusz Morawiecki. Normally there would be letters, 40 or 50 of these decisions, and I'm doing it out of my pure internal inclination. I'm just inquisitive as a lawyer, and I'm doing it as hobby. I want to get to the essence of law myself. So let me show you the ordinances which are unlawful. And then Ordinance of the Council of Ministers of the 19th of April 2020 on the establishment of certain restrictions, orders and bans in connection with the occurrence of a pandemic state. Next slide. It was 12,000 PLN imposition of a fine for running a business. It was not only about failing to comply with a temporary restriction on doing business as an office for permanent makeup established in an epidemic state. So in the next decisions, we learned that it was not possible and it was unlawful to close a business, somebody's business, because it was not permitted under an act of law. So there was no state of disaster, so such a ban constituted a flagrant infringement of the rights and freedoms of a citizen. Many companies went bankrupt. Many of them couldn't get even people committed suicide. So these were very important cases which were direct consequences of the bans imposed. And on the next slide, we will also see that this fine of 12,000 was cancelled and the administrative procedure was redeemed. And of course, the justification is quite similar, that it does not meet the constitutional condition of the issuance on the basis of a statutory authorization containing guidelines for the content of the Executive Act. Next slide, please. So to wrap up, the ordinance of the 19th of April 2020 and on the 16th of May 2020, they were not compliant with relevant acts of law. And next, temporal limitation of business operations, which was a complete ban on the establishment of certain restrictions, orders and bans in connection with the outbreak of an epidemic condition by which the same restrictions were introduced. So it was absolutely unlawful to close any business that we had to, and that could be done by a state of disaster, and people would get their compensation for that. And now we have a new act of law introducing no compensation for the state of disaster, even if introduced unlawfully.
Chcieli przepychać, żeby prawo było prawem.
They're going to make attempts at introducing solutions so that you have the possibility to introduce some kind of strange 30-day emergency state without any damages paid. Moreover, it should be emphasized that the essence of freedom of business is to undertake, perform, and terminate business activities free for everyone on equal footing. Hence, the ban on the types of business activities specified therein encroaches on the nature of freedom of economic activity as defined by Article 22 of the Constitution. The prohibition on violating the essence of constitutional freedoms and rights does not as a rule apply in states of emergency, except for the exceptions referred in Article 233, 3.2.1. And then Article 233.3 of the Constitution defining the scope of restrictions on human and civil liberties and rights in state of disaster may restrict freedom of economic activity, and the constitutional condition for interfering with the essence of business freedom is to do so under this state of emergency. Yet one more judgment of the Voivodeship Court in Wrocław. This was a fine of 5,000 zlotys for failure in a state of epidemic to comply with the order of a certain method of movement and obligation to cover the mouth and nose in a place open to the public. It cannot be overlooked that in the state of the law applicable to the case there was no legal basis for considering that the obligation to cover the mouth and nose, because we have talked about business activity, now we're talking about the covering the face and mouth, nose and mouth, which is supposed to be commonplace, while there is no such legal basis, and the same goes for restrictions for meetings in the public, as well as the 2-meter distance is not based in the legal acts in force. The court has no doubt that the aforementioned regulation imposing an obligation to maintain a distance of not less than 2 meters from individuals when moving on foot, with exemptions, constituted an interference with civil rights and freedoms enshrined in the Constitution. Again, now the court in Warsaw, in fact, is in Wrocław, confirms the same, that is, government had no legal grounds to take such action. Now, Opole, this was about a hairdresser's, quite well known, this case was. A fine for 10,000 zlotys for failure to comply with the temporary restriction on the operation of hairdressing salons by entrepreneurs. Unfortunately, the Council of Ministers did not use the opportunity of Article 233, and which would have given them the opportunity to restrict operation of such joints as hairdresser salons. Now, this is interesting because very often in these judgments, there's the grounds quoted along the lines that if I want to do something in the protection of health, public health, like the distance, face masks, it could be done, possibly, but only by law. So the decision makers, knowing the Polish legal framework and making decisions that they were aware of these decisions' unlawfulness. This was stressed by judges. And they did it knowingly because the government's legal center gave a negative view of their lawfulness. They introduced these measures nonetheless, and the courts say that the responsibility is thus higher. The courts say that if you had the opportunity to do this in line with the law, you should have, because you are the one who is supposed to be the guardian of these laws, and by implementing something without the state of emergency, this cannot be justified by any force majeure and state of emergency if the adequate provisions were not used to that respect. In order to introduce restrictions on human freedoms and rights, extraordinary circumstances cannot be invoked to justify special legal arrangements. This refers to Article 22 of the Constitution, the court ruled that the self-imposed lawmaking activity undertaken in this regard has led to the regulation of statutory matter and the violation of a number of fundamental freedoms and rights of the individual. And the Council of Ministers was only entitled to introduce some restrictions, but not to that extent. Let's continue. One more, please. The essence of freedom of economic activity thus includes its initiation, performance, and termination, has the prohibition of the performance of these types of business activities specified therein by successive instances since March 31st, 2020, including the Ordinance of April 19th, 2020, certainly encroaches on the essence of freedom of economic activity as defined by Article 22 of the Polish Constitution. This makes it clearly visible. It is my dream for every citizen, for every man and woman, be aware of this information so that everybody sees this and knows this. We have been tricked, you know. We should seek justice, national justice. Let's now move to the Supreme Administrative Court. Orders and restrictions can be considered legitimate from the point of view of combating the pandemic. Their introduction led to violations of basic constitutional standards, and one should share the position presented in the case law that no practical or pragmatic considerations, as well as the expediency of the introduced solutions, justifying going beyond the limits of statutory authorizations. The same goes for fines of 300 zlotys and such for face masks and similar. This is one of two rulings no legal measure introduced by the authorities can breach the freedom of movement provisions in the binding law and similar. This is of 10th of April 2020. Containing the extended freedom of movement of citizens throughout the country, violated the regulation of Article 52. Which means that it could not create a legal basis for fitting the scope of the sanctioned norm of Article 54 of the Criminal Code and provide a basis for incurring the criminal liability under this provision. Now, May 16th, signed by the Prime Minister. Let's move on. This is 6th. Let me just show that there is a 6th ordinance of June 19th, 2020. Yes, June 19th, 2020. Yet more rulings. Well, the Supreme Administrative Court, among others. Let's not repeat this. Ordinance 7 of August 7th, 2020, which is unlawful. Again, rulings confirming that. Ordinance number 8, and again 19th of October 2020, and several rulings confirming the unlawful character of that ordinance. And for example, 10,000 zlotys fine for a mass gathering. Apparently, 3 people could not meet. That made a group of 3 strong group constituted already a mass gathering. So Poles could not gather, could not express their dissatisfaction publicly. Already that was suspicious, and then there was an association that was fined. And the next slide is interesting because this refers to the European Convention on Human Rights, Article 11, Section 2, and the European Charter of Human Rights and Fundamental Freedoms, and referring to the keeping obligatory distance from each other, maintaining the indicated safeguards such as covering the mouth and nose, etc. And this is again confirmed in rulings, court decisions. Consequently, the violation of the aforementioned provisions of the legislation and the restriction of the same was in breach of constitution, and so on and so on. Now, the 9th ordinance of December 21, 2020. Rulings. This is a nice workload, you know. This took me several months to find the individual rulings referring to individual ordinances. And I think one day I will write a book about this. December 21st. Next slide. Even more rulings, and yet another. And one more. And a very interesting ruling of the Supreme Court. This is of March 16th, 2021. In the case 2KK7421. The law of December 5th, 2008 on prevention and control of infections and infectious diseases in humans does not contain nor specifying the possibility and conditions of limiting the unconstitutional freedom of movement within the territory of the Republic of Poland. So, legal acts of a rank lower than the law cannot limit this freedom of movement, which is guaranteed in the Article 52, Section 1 of the Polish Constitution. So we're not talking administrative courts anymore. This is the Supreme Court, and yet another slide from this court judgment. Therefore, it is clear that the defense of the Council of Ministers of March 31st, 2020, of the establishment of certain restrictions, orders, and prohibitions in connection with the occurrence of an epidemic state to the extent that it restricted the freedom of movement of citizens throughout the country, violated the regulations of Article 52, Article 31 of the Constitution, which means that it could not create a legal basis for filling in the blank of the sanctioned norm of Article 54 of the Criminal Code, and led to punishment, and could not lead to punishment under this provision. One more slide. I think we have one more excerpt from this judgment left. Therefore, given this circumstance and bearing in mind the norm of Article 92, Section 2 of the Constitution of the Republic of Poland, which excludes the permissibility of creating provisions of an executive regulation in isolation from the purpose of the law, or in contradiction to its substantive solutions, which would lead to the creation of provisions bearing the hallmarks of an independent legal norm, it must consequently be concluded that the regulation of April 10, 2020 could not constitute an effective legal tool to establish for citizens a ban on movement within the territory of the Republic of Poland. Failure to meet the requirements of the ordinance in this regard must result in the assessment that for this reason as well, the provision of the ordinance that prohibits freedom of movement within the Republic of Poland must be considered unconstitutional. This is in brief. Concerning that dictatorship, which hopefully will not be resurrected. I am very happy that Polish and European and worldwide lawyers work in unison, and the association works, and the rule of law is there, and we just need to bear them accountable against the rule of law that we already have in place. This shows you that the government is teaching the society to breach the law, which is very dangerous, because this sets example. So a headmaster of a school can introduce some ordinance that will be in breach of the law. Well, should the society be teaching, learning from, by example, from our government? This shows that the decisions were made that were unlawful. This has to be rectified. The example set by the government was very, very bad. We need to go back to a high quality of legal culture of Poland and Europe. And this is something I wish for everybody. Congratulations to all those capable of making decisions regardless of the pressure from above. Thank you. Thank you very much. Thank you. Thank you for this presentation. This gives us even more proof on the one hand, and on the other hand, the question arises, where are those that gathered in such large numbers shouting Constitution? Where have they been in the last 2 years? Would you like to comment? Thank you very much indeed. This is very, very interesting. You have carried out an astonishing load of work, and the conclusions, like Włodzimierz Skalik suggests, currently busy organizing the transmission of this event. The conclusion should be legislative. That is, if this has been confirmed, the unlawfulness has been confirmed by such ample body of judgments, then the question arises, can we draft an act of law that would suggest that damages should be paid by law to all those who have suffered, so that they don't have to go through the process of individual cases brought to courts in every individual person? This is the question. Conclusions should be drawn by lawyers. They are the ones to analyze the material that you have gathered, and they are the ones to put forward a proposed solution. Dear Chair, I think we're drawing to an end. Yes, we are indeed, but I still would like to ask Adam Kania to wrap up, the coordinator of the Nuremberg 2.0 project.
Thank you very much, but before, maybe a short wrap-up of what was presented by Dr. Marcin Sowiński. So, to shed some light at a broader context, of course, the administrative courts were on guard of law, which cannot be told by common courts. But even if we take even a broader look at this landscape and taking into account the Act on Counteracting Infectious Diseases and Infections of 2020, which was quoted in all the ordinances, we should take a step back and take a look at this from a perspective, because in line with this act, which was quoted in all ordinance, in Article 8, we have principles of operations in case of epidemic threat and the state of epidemic. Article 46, Section 1, setting out that the state of epidemic threat or the state of epidemic on the territory of voivodeship is announced and revoked by the voivode upon the request of the national sanitary inspector. So if the threat of epidemic occurs on the territory of more than one region, the state of epidemic threat or of the epidemic is announced and revoked under an ordinance. The competent Minister for Health, in coordination with the competent Minister of the Public Administration, under the request of the Chief Sanitary Officer, Inspector. So we have writs and answers to requests for the access to public information that no such request issued by the Chief Sanitary Inspector is appended, and there is no trace of a decision or request issued by the Minister of Health. So two ministers can be such good colleagues and great collaborators that maybe they agreed that maybe it was a kind of telepathic connection. So it's not a solid evidence for a court, but the request of the chief sanitary officer is important, because in Poland we have no chief sanitary inspector, and we don't have a person acting as one. We have only a person who is a substitute. So they carry out some activities, but the legal entity as the chief sanitary inspector, they doesn't exist. So this House of Cards collapses after stating that this key function is not present. And lawfulness, but we can see some light in this tunnel, as in the form of the decisions issued by the administrative court, and this is a good prognostic for the future. And yet another important aspect with regard to what was said by the fourth speaker, the Sanepid Plus action, so holding the sanitary authority accountable for what they did. I was taking part on numerous hearings for lodging complaints as a Polish Vita Foundation. Of course, there are many public prosecutor office which did not instigate the proceedings even, but we will investigate that and the reasoning. But this argument that emerges even during the hearings, and also policemen open their eyes widely when they hear that. But Polish men and women, it's a great opportunity and great chance for all of you to seek justice with regard to this detrimental experience which was caused by the actions taken by the Polish government. So we have full right. It would be great to have such an act, but before we can seek justice at courts and we can fight for at least our honor and to have a moral victory. So please visit us on our website, Nuremberg.2.0. You will find all documents together with the letter for a local public prosecutor's office in order to join such class actions, because if you don't do it, and public prosecutors will be notified by us, and there will be no application by harmed people, they will tell that there is no evidence for the problem to erase. So if they find a pile of documents and applications on their desks, they will find it more difficult to hide the matter under the carpet, to sweep the problem under the carpet. So let's act. Thank you very much. Thank you, Adam Kania. I would like to say a big thank you to all of you for joining us. And first and foremost, I would like to thank to all our guests from abroad. It was Georg Prchlik, a lawyer from Austria. It was Professor Dolores Cahill from Ireland, an immunologist, and Diane Protat, advocate from Paris. I'd like to thank to all guests invited, all guests from Poland, so Agnieszka Ozlowska and Dr. Marcin Sowiński. And I would like to thank yet another person who is usually forgotten, Włodzimierz Skalik, responsible for our broadcast, and Filip Molenda, supporting him for technical reasons. God bless you and thank you very much, ladies and gentlemen. My appreciation and gratitude to all of you who are standing strong and determined to fight for the right, freedom and truth, and fight for safety and health and life of us as human beings, and that all makes up for the standards of our civilization, and this is the most important ultimate goal we should fight for. Thank you very much for reminding us that even years ago these topics of sanitarism was tackled by me. At that time it was only crawling the obligation to vaccinate, the vaccination terrorism on the youngest. So, but at that time it was not felt in full for the general public. But thank you for reminding me that I presented that in the civilization perspective. So I hereby close the meeting of the Parliamentary Investigation Committee for infringement of law with regard to COVID-19. Let me wrap up the 30th meeting of the Parliamentary Investigation Committee Nuremberg .00. We kindly we send best regards from the lower chamber of the Parliament of the same in Poland, of the Parliament of Poland, and expect a follow-up because memento, Minister of Disease and Rapid Death announced another wave of the pandemic on January 2023. Ladies and gentlemen, these concrete men and women, Niedzielski, until Niedzielski is held accountable, people will bother us, they will deprive us of our dignity, property and freedom. We need to take action. Not only to take the revenge, and not because we're mischievous, not because we are too curious, which is over the norm with regard to the life of our friends. We are interested in all these cases of premature death and diseases and irregularities in the relationship between patients and doctors, between governors and being governed. It's not like we have nothing better to do. So we don't want to be small. We do it as a tool of self-defense because they are coming for us and they are threatening us with this club which has been prepared for us.
Narodów. On jest
These methods are still available to them, and thus we are acting in self-defense, and in self-defense are we obliged to bring these cases to court and put all of those men and women in jail, and hopefully there will be opportunity to do that both politically and legally. Thank you very much for being with us. Thank you very much for being with us. God bless you. Let's stay strong. Let's hopefully reach our goals. Thank you.